Greetings and welcome to this lecture on the Irish law of contract considering undue influence in Irish law. In the Allcard and Skinner case, the victimisation of others is not undue influence, and the courts will not protect an individual from their own folly. However, in the White and Mead case, a vulnerable person enjoys the presumption of undue influence upon them. In the Nicholl and Ryder case, this was a matter of a musician with drug abuse and dyslexia being taken advantage of by their manager, which was considered by the courts to be undue influence. The McGonigal and Black case considered an elderly neighbour who was subject to undue influence by another neighbour when they were deemed ill and lonely. The Prendergast and Joyce case considers a nephew taking undue influence on an elderly aunt with ill health and advanced age, and the Nova Scotia case in Hogan directs undue influence may occur where the individual is elderly and vulnerable. In the Danske Bank and Madden case, there was a presumption of undue influence in a solicitor-client relationship. There was a burden upon the solicitor to rebut such a presumption. In the Lambert and Lyons case, the proof of undue influence in wills differs from other inter vivos transactions, and therefore, once someone is dead, there cannot be the same consideration of undue influence as would be that in inter vivos or lifetime gift transactions. The ASB Bank and Harlech case considers that there is no presumption of trust between independent family members, and therefore there is not a presumption of undue influence. In the Barclays Bank and O'Brien case, there is no presumption of undue influence between spouses unless there is a reliance by one spouse on another for financial decisions. The IBRC, Irish Bank Resolution Company and Quinn case directs that the burden of proof for undue influence rests generally with the complainant. The Mackin and Hibernian Bank case directs that there is a presumption of undue influence in a parent-child relationship. The Gregg and Kidd case directs that there is a presumption on undue influence in relationships of trust. In O'Flanagan and Rager Limited, shareholders transferred property to a dominant party, and undue influence was later pled in the courts. The courts held that the use of a dominant position attracts a presumption of undue influence, and the courts can consider factors such as the advantageousness of the donor to the other individual and the imbalance of negotiation settings. In this case, it was highly disadvantageous to transfer the shares, and there had been an imbalanced negotiation setting. In the Hewitt and First Plus Financial Group, a man hosting a secret affair got his wife to mortgage her interest in the property. The marriage broke down on discovery of the affair by the man from the woman, and she sought undue influence. And the direction from the courts was undue influence did exist, and the concealment of key factor that would have influenced her payment was deemed to be the basis of this undue influence declaration. In the National Australian Bank and Noble case, Ulster, as supported by the Ulster Bank Ireland and Fitzgerald case, banks are accountable for undue influence that they ought to have reasonably detected or had constructive knowledge of. In the Credit Lyonnaise and Birch case, banks are directed to ensure an independent advice is sought by the individual, and in the Ulster Bank Ireland case and Roach, banks ought to inquire where a transaction is non-commercial in nature to ensure that independent advice has been sought. In the F&F case, independent advice sought from two or more sources prevents a claim of undue influence. The O'Kelly and Glennie case directs that courts are lenient on limitations in circumstances where there has been fraud or overbearing conduct, and the time starts from when the party is freed from this influence, and thus this is quite a subjective test in law. The AIB and Burn case directs that where there is undue influence on transactions, the courts are at liberty to simply set aside the entire transaction or uphold the transaction. In the Lunam and Kenny case, courts may compensate where the rescission orders are not feasible.